Thank you very much. It's a real honor to have been invited and to be able to contribute to this important discussion. I think I'll echo what Peter said. I don't think I've ever seen such an intimidatingly large crowd of people at a Freedom of Expression conference. So well done to the organizers on bringing so many people together. I'd like to use my time to make a few observations on one particular element in the ruling of Markus Pentikainen's case, and that is that the Finnish government argued, and the Grand Chamber seemed to agree, that journalists are not entitled, and I quote, to preferential or different treatment in comparison to other people at the scene of a protest. So in other words, if the police order the crowd to disperse, journalists are required to go too. The first comment I want to make on this is that the approach of the majority in the Grand Chamber actually, to me, seems to put journalists at a disadvantage compared to peaceful demonstrators. I'll try to illustrate that point with an example. So let's imagine that while Markus Pentikainen was taking pictures, there was a peaceful demonstrator standing next to him, waving a banner. Let's call him Mikko. I saw that that's one of the most popular names with an M in Finland. That's how I selected it. Both of them are arrested by the police for ignoring orders to disperse, and both of them are convicted without any sentence. But Mikko, the protester, also applies to the European Court of Human Rights and invokes Article 11 rather than, the article which deals with freedom of peaceful assembly, rather than Article 10 on freedom of expression. I think Mikko's case might play out a bit more favorably for him. Firstly, there is the aspect of ignoring the police order. I think that would be approached a little bit differently. In Marcus's case, the Grand Chamber said, and I quote, "Journalists cannot be exempted from their duty to obey the ordinary criminal law solely on the basis that Article 10 affords them protection." I think in Mikko's case, the Grand Chamber would probably refer to its ruling in Kudrvicius versus Lithuania, which was a case about protesting farmers who had blocked 3 major motorways and had then ignored the orders of the police to leave. In that case, the court stated, an unlawful situation does not necessarily justify an interference with a person's right to freedom of assembly. The authorities are still restricted by the proportionality requirement of Article 11. So I think that in Mikko's case, the burden would be more clearly on the Finnish authorities to justify their actions. Secondly, in Mikko's case, I think the court would probably express reservations about the use of criminal law. In the Kudrvicius case, the Grand Chamber held, let's go there, that a peaceful demonstration should not, in principle, be rendered subject to the threat of a criminal sanction. And you can contrast that to the statement in Pentikainen's case, where the Grand Chamber held, somewhat laconically in my opinion, that a journalist has to be aware that he or she assumes the risk of being subject to legal sanctions, including those of a criminal character, by not obeying the lawful orders of the police. Third point, I think the court might evaluate the effect of the conviction differently. In Marcus's case, as already been pointed out, the Grand Chamber felt that a slap on the wrist was not a big deal because it amounted only to a formal finding of the offence committed by him, and as such could hardly, if at all, have any chilling effect. And that sounds quite different from Kudrvicius, where the Grand Chamber stated that freedom to take part in a peaceful assembly is of such importance that a person cannot be subject to a sanction, even one at the lower end of the scale, so long as that person does not himself commit any reprehensible act. So the conclusion I would draw is the following. The court has often said that Article 11 must be interpreted in the light of Article 10, and Nemtsov versus Russia is an example of a case where the court has stated that. But it has never stated the reverse, that Article 10 should be interpreted in the light of Article 11. And to my mind, it should be a two-way street. The right to document during assemblies under Article 10 should not be any weaker than the right to participate in them under Article 11. There is actually a case currently pending before the court, Butkevich versus Russia, where I think this approach would be relevant. It's about a journalist who was covering a so-called unauthorized protest and was detained alongside some of the participants after ignoring the order of the police to disperse. Now, if you look at the court's case law under Article 11, it's a well-established principle that if a demonstration is unauthorized, that is not by itself a ground to disperse it. So if in this instance it's the case that the dispersal of the demonstration was not justified under Article 11, then surely the arrest of the journalist should not be justifiable either under Article 10. Now, the second bigger comment that I want to make is that, in my opinion, journalists should actually enjoy a certain degree of preferential or differential treatment compared to participants in an assembly. Why do I say that? Obviously not to belittle the importance of freedom of assembly, but on the contrary, because the presence of journalists is really an important guarantee for the right to demonstrate in two different ways. Firstly, because the media, they help to amplify the message of the demonstrators so that they ensure that their message is actually heard by the people to which it is addressed. And secondly, because the authorities are less likely to impose unreasonable restrictions on a demonstration or use excessive force against demonstrators if they know that they are being watched by the media. And of course, the Grand Chamber in the Pentikainen judgment recognized this second aspect, stating that the presence of the media is a guarantee that the authorities can be held to account for their conduct vis-à-vis the demonstrators. And as the dissenting judges also pointed out, that watchdog role of the press takes on a particular importance when the police consider that demonstrators are acting illegally and decide to make arrests or to disperse the protest. Of course, it is a sound principle that journalists should keep a respectful distance in these situations so that the police can do their work, and there's no debate about that. At the same time, journalists, and especially photographers and videographers like Marcus, they do need a good vantage point to record the events. And I think in some cases that means having to follow demonstrators when they trespass on private land, or staying near them, as in Marcus's case, when they're ignoring a dispersal order, rather than trying to get a shot from behind, far away, or from behind the police barrier. Now, the Grand Chamber acknowledges that journalists may face a conflict between their professional duties and the duty to abide by criminal law, but it then goes on to say that journalists just need to choose at their own risk. And I quote, "The concept of responsible journalism requires that whenever a journalist has to make a choice between the two duties, and if he or she makes the choice to the detriment of the duty to abide by ordinary criminal law, such journalist has to be aware that he or she assumes the risk of being subject to legal sanctions." It seems quite a lot to me to ask of journalists that they should engage in civil disobedience just in order to fulfill their public watchdog role. And I agree with the dissenting judges and the commentators who have argued that the question should not be just whether a journalist broke the law, but it should be whether enforcing the law against him or her is necessary and proportionate. And I think that's where the difference arises between demonstrators and journalists. There might sometimes be a pressing social need to prosecute demonstrators who trespass onto private land or who refuse a dispersal order, but I think that is less likely to be immediately the case for a journalist who is not taking any active part and is merely documenting the event. The third point I'd like to address is the position of observers who are not professional journalists. Should they too enjoy enhanced rights compared to participants in a demonstration? There is quite a well-established practice in some countries of NGOs or other organizations sending monitors to demonstrations to report on how the interaction between the participants and the police is working. There's actually an OSCE guide, which is the Handbook on Monitoring Freedom of Peaceful Assembly, which is intended as a guideline on how to conduct such exercises. There's also a growing trend of citizen journalists covering demonstrations. It's been mentioned before today, the case law of the court suggests that any privilege given to traditional journalists must also extend to other types of watchdogs. There's quite a long line of judgments recognizing that NGOs are entitled to similar protections as the press under Article 10. And in the recent Grand Chamber judgment in Magyar Helsinki Bizottság, that judgment suggests that some other groups may also enjoy enhanced protection, such as academic researchers, authors, and bloggers. There is, of course, a genuine practical concern about how the police can tell the difference between a participant in a demonstration and an NGO monitor, citizen journalist, or other type of watchdog, especially in a chaotic and fast-moving situation. But I think it's not really a basis to draw a distinction with traditional journalists because the same problem might arise there. They might also be difficult to distinguish from the crowd. So, where does the solution lie? First of all, I think journalists and other watchdogs should, where possible, make the work of the police easier, and they can do so by wearing distinctive clothing or signs. But I would argue against elevating that to the point of an absolute requirement, because sometimes impartial observers might risk becoming a target themselves. And in the Butkiewicz case, which I mentioned before, there is an intervention, an amicus brief by 3 NGOs, and they point actually to various guidelines on how the safety of journalists should be protected. And those guidelines state that it's a good idea for journalists in some situations to keep a low profile. So that's actually recommended as good practice.
Daniel, I need to ask you to wrap up.
Okay. Second point, the police should be required to release a person as soon as it becomes clear that he or she was merely acting as an impartial observer. And I think it's important there that continuing the detention that can lead to a delay of the release of the images, which might be perishable and not be so relevant anymore after a certain amount of time. Finally, I'd like to point to one more area where the courts might draw inspiration from the case law under Article 11, and that's the case of Frumkin versus Russia, case decided last year, where the Chamber held that there is a positive obligation for the police to communicate with the organizers of a demonstration to resolve any tensions that arise. And I hope that in due course a similar positive obligation will be recognized by the court for the police to engage in dialogue with the press and other public watchdogs before any major demonstration, so that they can agree on a process to make sure that journalists are not confused and watchdogs are not confused with participants, and to establish secure viewing areas and other measures. Thank you very much.